on the phone, it's a pleasure to welcome Emily Bazelon. She is a Slate senior editor and the Truman Capote Fellow at the Yale Law School. Welcome to the program, Emily.
Thanks for having me.
What is, I got to ask you, the Truman Capote Fellow?
Yes, Truman Capote's estate has donated money to Yale Law School to support nonfiction writing, so that's why I get to have that amazingly cool title.
That is an amazingly cool title. All right, so let's talk about this. This is the court case on Monday. Judge Richard Leon. He was a Bush appointee judge. He is a judge with the Washington Circuit Court, and this is the first time that a federal court has ruled the NSA metadata collection program unconstitutional. Tell us what break the ruling down for us.
Well, the ruling has kind of two really important parts. The first part is Judge Leon's skepticism that the government really has shown it has a compelling interest in collecting all this metadata. And I think the most shocking part of the opinion was Judge Leon saying that the government had not cited a single instance in which this database solved an urgent terrorism case, thwarted an imminent terrorist attack. And that's important because the whole idea of having all this data searchable without a warrant, without judicial review, is that we really need to get access to tracing down terrorists very quickly. Yet the government couldn't cite a single instance in which that had actually really helped and had really mattered.
And part of this, I mean, so this is basically a test as to whether or not the government's interest is compelling and unique enough to warrant superseding the Fourth Amendment. And his argument was that, I guess the first part of that argument was that you're just looking to do it faster, right? I mean, wasn't that part of it? Is that, like, you already have the ability to do this, you just want to do it faster?
Yes, exactly. That, no one is arguing that the government can't search for terrorists. This is about how much searching can happen without a warrant. And the way this metadata is collected, the government, the NSA, starts with what they call a seed. That's a phone number that's associated with a terrorist group. Then from that seed, they've given themselves the power to look at all the calls from that number, and then all the calls from those numbers, and then all the calls from the second-tier numbers. So we are talking about everybody's metadata very quickly. And metadata isn't the content of phone calls, but it's everything else. So people know exactly who you're calling and how long you stayed on the phone for and when. And so that's, a lot of personal information. And the other important part of Judge Leon's ruling was to say people really do have a privacy interest in this. And it's one that the Supreme Court has never really dealt with because all of this intense using of cell phones and telephones that we do is relatively new.
And in this instance, and I want to get to that second part in just a moment, but he cited, I guess he used like a Domino's pizza example, and I just want to walk through this to make it really clear. So the seed, I guess their use of the seed calls involves, like, if I call Domino's, then Domino's is now sort of like part of the catchment, as it were, right? I mean, it becomes almost infected. And then anybody else who calls Domino's also becomes part of the catchment.
Exactly. And from that example, it's a really good concrete way of understanding why it is that everybody's metadata is in this database. However distant terrorism may seem from you, once you call a place like Domino's that someone associated with the terrorist might have called, you are in there too.
Right, and then so on, et cetera. And so that's one of the big problems. And then you turn to the and then we turn to the second issue. And when this when the Snowden disclosures first came about, people very often cited this case, Smith v. Maryland, and that's the one that where Judge Leon says, he basically says that case is not applicable here. So let's walk through that for us.
Yeah, sure. That's a 1979 Supreme Court ruling in which the court said that if you voluntarily give your billing and your calling information to the phone company, just as part of your normal having a phone, then you are not expecting to keep that information private anymore, and the government can search it. Now, the question is, that was 1979. What relevance does this have to the metadata the government now collects? And the NSA has all along been arguing, look, this case is very much on point, and until and unless the Supreme Court changes its mind, we're not violating the Fourth Amendment. All the court judicial review before Judge Leon has agreed with the Supreme Court on that point. Judge Leon said, you know what, we just live in such a different world now. The Supreme Court could never have imagined all the data that these phone companies collect on us, and it's time to just rethink the relevance of this old case.
And he leans heavily on a 2012 case, Jones, that involved GPS. Is that right?
That's right. That's a case in which the court said it was unconstitutional for the police to put a GPS tracker on your car without a warrant. And in that case, there's a lot of really cautionary language about new technology and how invasive it can be to people's privacy, and how the courts want to make sure that the police are getting warrants before they use that kind of technology.
And how, I've been reading quite a bit on the perspective that many writers are having on this, court watchers and whatnot, and people who are digging into this, think that's sort of his argument is not terribly compelling there, because the metadata that is supposedly being collected of those phones is really isolated to the same type of metadata that was collected in Smith v. Maryland. What's your take on that?
Well, I think that it's similar in that it's on your phone bill. On the other hand, the amount that we use our cell phones, the way they are basically tracking every single message we're sending out, the way we're talking about text messages and emails as well as phone calls, makes this, in terms of the amount of information we're giving away, it just is a very different world than the 1979 phone use in Smith versus Maryland. So to me, the distinction that Judge Leon is drawing here makes a lot of sense.
So it's less that the phones have more technological capability, but more about how we as human beings interact in some ways with our phones. Exactly. Yeah, that's an interesting concept. Now, let's go through just a couple of the other sort of issues here that are different than any case that was brought up, let's say, a year or two ago. And we should also say, well, first off, before we even get to there, well, let's start with this, that there is now one of the things that became very clear is that the issue of standing, at the very least, to bring these cases seems to be now resolved. This just walk us through what that means, both in terms of what it literally means insofar as standing, but also what the implications are of that going forward with other cases.
Well, standing is just the ability to get into court to have your case heard. And the Constitution says that you have to have a live case or controversy. And over the years, there's been lots of law, lots of rulings about what exactly that means, who gets to come into court for what kind of case. When people have tried to challenge the NSA's data collection and surveillance before, the courts have generally said, you know what, you can't prove that your data was actually collected because this is all secret, so you don't have standing. It was basically an easy way for courts to just stay out of this whole situation, this whole question. But now we know from the Snowden revelations that essentially everybody's metadata is being collected. And the government has essentially conceded that point, and that is why the plaintiffs in this particular case had standing in Judge Leon's view.
And so how does, now we should also say that there was another federal court in San Diego that a couple of months ago, I think it was, basically found, I'm not exactly sure, but tell us what that finding was. Do you know that case? I think it was a Judge Miller. and that case failed or at least the finding was such that this was not a violation of the Fourth Amendment. Tell us a little bit about that case.
Well, you're right. I mean, that case was also about the same constitutional questions, and then there's also a question of whether the NSA is violating the federal law that we think it's called FISA, the Foreign Intelligence Surveillance Act. And that court said that the answer was no, saw this differently from Judge Leon. There is another case pending, a suit in New York that the ACLU has brought, and I think what we're going to see over the next months are a bunch of rulings from different district courts. That's the first level. And then also we're going to start to see some appeals happening pretty quickly. Judge Leon stayed his order. That means it doesn't go into effect until after there's an appeal. So that means the Second Circuit Court of Appeals, which is the federal appeals court in New York and a couple of other states, will get to weigh in on this. And, eventually these suits, one of them presumably will probably make it up to the Supreme Court. By then, we'll have a bunch of different judges weighing in on these questions.
And we should say, in this case, the judge stayed his decision basically to give the government an opportunity to appeal because this is such an important national security question, I guess. He basically ruled that, look, the two plaintiffs, Larry Klayman and Charles Strange, they probably did have their constitutional rights violated. I'm going to stay the order. And this only applies to them, but because they did this based on the fact that they're Verizon customers, and we know from Edward Snowden's leaks that Verizon customers were subject to the same treatment, that's why the ACLU can bring this case in New York.
That's exactly right. And the other procedural just point to make to finish it off is that this is about a preliminary injunction. So the reason Judge Leon said they'll probably win is that at this standard, this early part of the proceedings, he doesn't have all of the evidence beforehand, and he is making this initial determination. So there'll be an appeal of his ruling, and then presumably the case will come back, and it will be fully aired before him, and then it will go back up. So there's lots of different stages to this. And he was doing the prudent thing here by not putting into effect what would be a very dramatic change in government policy in order to give the higher courts a chance to weigh in.
And do you have a sense? I mean, so this when the government appeals, it goes to the First Circuit of Appeals in D.C., which of course is not only considered, I guess, the second highest court, more or less, in the country, but it has also been in the news because this is the court that the filibuster reform was at least predicated upon filling those empty judgeships there, I guess. And so do you have a sense of with the new judges coming on, where that court might go with this? I mean, can we because of the nature and the way that they hear these appeals, where they do a sort of three judges picked at random, is there any way to sort of predict, or do we really need to know who the judges are first? And even then, is there a way for us to predict where this is going to go?
Well, that's a really good point and a good question. You're right. The way a federal appeals court works, there's a panel of three judges that hears the case, and that is random. It could be three conservative Republican appointees. It could be three more liberal judges picked by Democrats. But after that initial panel hearing, there is this other step, which has the Latin name en banc review. And that's just a way of saying that at that point, the whole appeals court, in the D.C. Circuit's case, that's 12 active judges. They all review the case. So at that point, the composition of the case and the ideologies of the judges really do start to matter and become more predictable. And you're also right that President Obama has recently appointed three people to that court. So it is no longer dominated by judges picked by Republican presidents as it was before.
And so, I mean, at the end of the day, when we sort of analyze the impact of this case, Give me a sense of how you think this is going to impact the next round of cases. I mean, what will be taken from Judge Leon's ruling, and how will that sort of impact what other cases we hear, at least on a trial judge level, on the first non-appellate level?
Well, this is a really hard set of questions, whether there's a constitutional violation here. And I think inevitably, as we've already seen, judges are going to make different calls about this. The question I have about this ruling is whether it is a wake-up call both for Congress to do something and also for the NSA itself to reform its own practices, because there's nothing stopping the NSA from changing the way it does business. And if it's true that they are not thwarting imminent terrorist attacks with this enormous data collection, then you would hope that some people inside the agency would start to question whether they are in fact violating people's privacy more than is really necessary.
Yeah, and so we've already seen, I think yesterday, Harry Reid announced that he was more open, it seems, to legislation that would reform the NSA process. I think Wyden and Udall were already citing this case as a need for reform. And so in many ways, the implications of this are almost more sort of political and policy than legal.
I think that's right, and it's a really interesting effect that one district court judge can have, right? He only has the authority in his own courtroom, but he has managed to change the whole political conversation about this kind of data collection.
And I would imagine also it starts to begin to implicate the sort of conventional wisdom on the question as to whether or not Edward Snowden is a legitimate whistleblower.
I think that's right, too. I mean, that was a point that I wanted to make when I was writing about this week, is that, you know, we are seeing the government, the Obama administration, saying they are intent on prosecuting Edward Snowden. Well, if he led to these revelations that have shown that a government program is different than what the NSA presented it as, because we know that's true, and is also potentially unconstitutional, then you might argue that he should be hailed as a hero, or at least not sent to prison for the leaks that he did.
Right. I mean, this definitely makes it less definitive. I mean, it's much harder for people to sort of definitively say that he's not a whistleblower, because clearly, if it was just up to Judge Leon, he would undoubtedly be one, it seems to me.
I think that's right. And, you know, the other thing is that there is just no question we would not have this case. These plaintiffs would not have had standing, would not have gotten into court without the Snowden leaks. And so in that sense, you really see a direct cause and effect and a huge impact here.
And you know, one other aspect of this that really strikes me is that this really casts into sort of bright light the difference between our, I don't know, for lack of a better word, our normal judicial process and the sort of the parallel track that is the FISA court. I mean, one of the things that has struck me since the beginning of these revelations and the sort of the subsequent drip of rulings that have been released from the FISA court is how the FISA court has changed in its nature from the way that it was set up, from a court that basically issued national security bench warrants into one that was interpreting law. Can you just talk about the different implications? Because, you know, one court is adversarial and another court is it's just the government there arguing. There's no one to even appeal the rulings.
Right, and you can argue that it's maybe not even a court in the sense that it was completely secret and closed. And as you're saying, there's no adversarial process. It's the government coming, making a representation about why they need to do surveillance without a warrant, and the judges ruling up or down. And as Judge Leon pointed out, there have been 15 judges over 35 years, 15 judges issuing 35 rulings saying that this metadata collection was constitutional and allowing it to go forward. It was only Judge Leon who disagreed in the open court where you have scrutiny, you have a sense of what is actually going on. And I think that really does make, in this case, it made all the difference.
Yeah, well, you have a plaintiff, right? I mean, you actually have someone who's arguing against the government's case that this is legal, where in the FISA court you don't. And I'm not even clear on what the process is. I mean, is there any type of appellate process for the interpretations of the FISA court by a plaintiff? I mean, is there even how would someone... If someone dissented, and I guess the issue is that they wouldn't know to dissent, but if someone had dissented against the FISA court rulings that said, yes, not just in this instance, we're not going to just issue a warrant but we're going to give you this blanket authority based upon your argument as to what the interpretation of the amended FISA Act is or the Patriot Act is, there's no one to argue against that.
Right. I mean, the judges themselves can be skeptical and ask questions. And there have been instances in which the FISA court got worried that the government was overstepping its bounds, misrepresenting the data collection, or just going beyond the scope of an order. So we now have those rulings. Those were only made public after the Snowden revelations. But you're also right. This is a much more limited kind of judicial review.
Right, and I think one of the things that those released opinions showed too is that the FISA court really has no mechanism in which to make the NSA comply with its orders.
Right, there is that problem as well. I mean, one hopes that the NSA would do so, but there is a sort of hidden nature to a lot of this, and I think also the FISA court. Whenever you have judges ruling in secret and only hearing one side of the story, you just wonder whether they're going to be somewhat captured by the whole process, and is one in which it's kind of thankless for them to be protesting. Also, the FISA court judges are selected to a large degree by Chief Justice John Roberts, and he was selecting a lot of conservative Republicans to serve on that court. We know that.
And so just from a practical standpoint, I mean, when do you think what is the timing of something like this to be brought up on appeal? I mean, what literally happens next?
Well, the appeal to the D.C. Circuit is expedited, so it's going to happen pretty quickly over the next, weeks, and I think we can probably expect an opinion from them in the coming months, sometime this winter or spring. And then, as I said before, there will be other cases that start to bubble up as well. But I guess the big question will be, could this come up for Supreme Court review in the term for next year? That seems pretty quick, but I don't think it's completely impossible, although it might be more likely to happen the year after next.
Well, assuming that it goes to appeal rather quickly and that there is a ruling and one side or the other will appeal to the Supreme Court, what is the window for the Supreme Court to accept, to certification?
Well, they accept cert petitions all year round. They take a break in the summer for a little while, but essentially they can do that whenever they want, and they can move as quickly as they want to. I have to say, though, I would be really surprised if this issue ends up squarely being decided by the Supreme Court, because I would really expect the president, whether it's President Obama or someone else by the time this comes up, to make some changes, because it would just be so dramatic for the Supreme Court to rule this kind of program to be unconstitutional. I would think whoever is in office would really try to avoid that.
Well, based upon what Judge Leon ruled, what would the NSA have to do to essentially avoid avoid this notion of them violating the Fourth Amendment?
Well, that's an excellent question, and I don't think there's just one answer. I think you can see a few points of potential legal vulnerability for the NSA, and they could try to change one of them and then go back and see if Judge Leon would find the change acceptable. So, for example, they collect all this data but then they go in and search and analyze it without a warrant. So one thing they could do would be to say, well, we're going to keep collecting it, but we won't search and analyze it unless we have what's called reasonable and articulable suspicion. In other words, that we have one target in mind who we're looking for, and we can tell you why we're worried about that particular target. That's one kind of change they could make that might reassure a judge like this one.
Okay. Well, Emily Bazelon, thank you so much for your time today. Really appreciate your walking us through this, and it's obviously something that we've all got to pay attention to over the next coming weeks and months.
Yes, agreed, and thanks so much for your great questions.